So,
Good evening,
on
sir.
behalf of IPNet, I extend a very warm welcome to the guest speakers and all participants and fellow IPs in this 11th webinar on a very interesting and highly relevant topic, which is actually enhancing NCLT functioning insights from the Jet Airways judgment, which is actually a recent judgment. I'm delighted to share that we are, as of now, in the August presence of our guest speakers, Mr. PSN Prasad, who is ex-NCLT member, Mr. V. Nalasarempati, senior advocate, ex-NCLT member, IP Mr. Narendra Kumar Sharma, Mr. Rohit Kapoor, senior advocate, ex-NCLT member. So I have to see whether everybody has joined or not, but yes, we will be having their August presence today. And this is to bring to the notice of attendees of this webinar, specifically our respected guest speakers, that this is the 11th webinar organized by IPNet in the series of webinars organized from time to time under the umbrella of IPNet, National Network for Insolvency Professionals, since its inauguration on 7th of September 2024. Are each of the 4 regions of IPNet is regularly organizing weekly webinars on contemporary and highly relevant topics on a rotational basis. These webinars are making huge value addition in the knowledge of IPs attending these webinars, and is also giving a new perspective to the professionals under the able guidance of our IPNet President, Dr. Ashish Makhija, and his team. Moving forward, please allow me to invite our IPNet President, Dr. Ashish Makhija, for a formal welcome address. Ashish sir, the stage is all yours.
Thank you, Sandeep ji. Friends, before I begin, I think we have a galaxy of speakers today. May I request everyone to please open their videos as a mark of respect, because it's not a faceless meeting. We must see each other smiling faces that we can interact also. And I'll request everyone to please keep their mics muted unless you are speaking. Thank you so much. I think I can request Parag to take a screenshot of this, of all smiling faces, including all our guest speakers. Okay, good afternoon, everyone. On behalf of IPNet, which was inaugurated on 7 September 2024, not a very long time ago. Friends, please, can I request everyone to please keep their mics muted? Yeah, thank you. So on behalf of IPNet, friends, I'm extremely delighted to welcome you all to today's webinar on a very interesting topic, enhancing NCLT functioning, insights from the Jet Airways judgment. Friends, this subject is of immense importance, as the effective functioning of NCLT is pivotal to ensuring the success of insolvency and bankruptcy process in India. The lessons which are drawn from the landmark judgments, such as the Jet Airways case, a recent judgment by the Honorable Supreme Court, it offers us a very unique opportunity to reflect upon the existing framework and also to explore avenues for improvement. We are privileged to have with us an exceptional panel of speakers today, whom we are very thankful that they could spare time. Mr. PSN Prasad, who is a former NCLT member, Mr. V. Nalla Senapati, who is also a former NCLT member and also acting as an advocate nowadays, and definitely a dear friend, Mr. Rohit Kapoor, who is also a former NCLT member and a senior advocate, and of course, a very seasoned insolvency professional, Mr. Narendra Sharma. Each of them, friends, brings a wealth of experience, practical insights, and an extremely deep understanding of the nuances of insolvency proceedings and NCLT functioning. I also take this opportunity to thank Tina Saraswat Pandey. She's also an insolvency professional and a member of IPNet, who will be moderating today's discussion with her expertise and finesse. Throughout this session, friends, we aim to delve into the critical aspects of NCLT operations, analyze the learnings, and also discuss actionable insights that can enhance efficiency and can also bring back the trust in the system. Of course, NCLTs were constituted in the year 2016, and they have been working very well despite the pressure which is there. But still, there is always a scope for improvement. Before we begin, I would also like to thank all the participants for joining us today. I think the presence of all the IPs, a large number of IPs here, reflects the commitment of the insolvency community to engage with the very important issues and also to contribute to the solutions to uphold the spirit of insolvency and bankruptcy code. Friends, let us together make this session an interactive and enriching experience. And with these words, I will hand over the session back to Mr. Sandeep Chitkara for further proceeding. Thank you, and I wish all of us a productive and an insightful discussion. Thank you so much.
Thanks, Makija sir, for your welcome address. So now I invite moderator of today's session, Mrs. Tina, to take this session further. And I also invite Mr. Parag Singhal to introduce our first speaker.
Thank you, Sandeep ji.
Thank you, Sandeep ji. And before I introduce our esteemed speakers, please allow me 2 minutes to display the IPNet slides which we have made. Kindly allow.
Okay, sir.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Thank you, everyone. And since our guest speakers are here for the first time among us, I'll be running a very short slide of the website that we have developed for IPNet. Thank you, everyone, for the patient hearing. Now, I have the honor to welcome our first guest speaker, Shri E.S.N. Prasad. As you all know, he is a senior advocate and ex-NCLT member. I have a brief introduction of Mr. Prasad. I'm honored to introduce him to all of you. He is an accomplished legal scholar and practitioner. Mr. Prasad holds an LLM from Rashtra Sant Tukadoji Maharaj Nagpur University and is pursuing his PhD in law from Mumbai University. Before his tenure as judicial member of the NCLT, he served as a legal advisor in the Reserve Bank of India Central Office, Mumbai, at the rank of Chief General Manager. He has also undertaken prestigious training, including courses on arbitration and ADR, public debt management, and intellectual property rights from UNITAR and WIPO, Switzerland. Shri Prasad's stellar career spans over 3 decades, and he has contributed significantly to the legal field as a practitioner, advisor, and academic. He has authored nearly 25 articles and has been a visiting faculty at many esteemed institutions. It is indeed a privilege to have him share his expertise with us today. I request moderator Kinaji to please invite Mr. Prasad. So moving forward, we'll invite Mr. Prasad again. We have among us Mr. Rohit Kapoor. He is also a senior advocate and ex-NCLT member. Mr. Kapoor started practice in the office of the then Advocate General, who later became the Chief Justice of the High Court. Before practicing in the Supreme Court of India, he practiced in high courts, subordinate courts, and tribunals, including arbitral tribunal. He was senior standing counsel for various boards and organizations. He served as Additional Advocate General 2016 to 18 for the state of Jammu and Kashmir. He practiced arbitration and has experience of various arbitrary tribunals and high courts. He was standing counsel of Central Bureau of Investigation. He served as member of State Juvenile. He was a member of State Juvenile Justice Board under Preconception and Prenatal Diagnostic Techniques Act 1994. He was appointed as judicial member NCLT in September 2021. He has authored around 32 publications so far. We are indeed privileged to have Mr. Rohit Kapoor sir among us for sharing his rich experience in the legal domain. Moderator ma'am, please invite Rohit sir.
I would request Rohit Kapoor sir to share his experience as an NCLT member and also his suggestions for improvement in NCLT working.
Thank you. First of all, thank you so much for having me here. See, you put a caveat in the beginning of 5 to 7 minutes, and 3 years experience sharing will be a little. Anyway, I'll try to. But honestly speaking, this Jet Airways, because once we were sitting on the bench, Mr. Prasad is there, Mr. Nalapati is there, that many things were in our mind. But somehow we could not have expressed opinions as such. Now, Mr. Makheja has given us that platform to give our thoughts a vent. And first of all, I would say, we are seeing many things in the the conferences, the seminars or these platforms, how to strengthen this insolvency, how it is important for the economy. I think that is not the subject matter, we all know. And as far as the effective functioning is concerned, there are many factors. Now those factors perhaps been very recently highlighted in Jet Airways, and those this is an increase in the infrastructure, increase in the strength, and the knowledge. The persons who are appointed as the NCLT members or the NCLT members must possess the domain knowledge. That is to say, the persons, particularly the judicial members, they should have the expert knowledge of the company law, the insolvency law, and this is an area which is coming in my mind, and I want to speak to. The question is, they have said it sounds very wonderful, very attractive when we see that we must have the members with knowledge and the expert knowledge, rather. The word expert knowledge, not merely knowledge, the expert in the domain expertise. But the question is, question comes from where to get. And see, what my experience is that I asked many lawyers who are working in this field, and why don't you come forward and become the members of the NCLT? And as you know, the minimum age prescribed is 50 in the tribunal. By the time they reach 50, they are so well established. They don't want to come to the tribunal. Maybe it doesn't have all those very attractive financial terms and conditions, or the money which the a lawyer, Mr. Makheja, will be earning. I don't know whether he ever applied. I would like to ask him, and he has to answer for that. If he has not applied, why he is not? He is having the expert knowledge. He has the full. He has the no. He's the most eligible person to have applied for the NCLT also. I'll ask him. So, so these are the questions. So with the passage of, and honestly telling, I came from a place. Are you able to hear? Are you able to hear?
Yes, sir. Yes,
Yes.
very
Yes.
much audible.
Very
So,
clear.
so in
Yes,
fact,
sir.
when
Yes, sir, very clear.
honestly, when I joined this, and when I was the bench, so at times, persons like very experts were appearing. तो मुझे लगता था कोई हवाइयां उड़ रही हैं मेरे कानों के आगे पीछे ना, मुझे नहीं पता लग रहा था. Honestly, it took me some time. So to suffice it to say, first of all, in the high courts also, not many their matters are not there. The NCLT matters. So the source of expert knowledge remains the young and the dynamic lawyers in particular, which I have not seen many lawyers have been appointed to the NCLT so far. Many, not many. I think at the most there should be, since its inception, Mr. Prasad will be correcting me, Mr. Makheja will be correcting me, not 3 to 5, not more than that. So it is I think it is a very appropriate observation by the Honorable Supreme Court that the to make it for the effective, we must have the members who have at least some knowledge about the subject, and of course the legal acumen, the power to the competence to adopt to the legal arguments, that is always there. But this is what my experience is, that this is the IBC and the company law at times, it involves very complex propositions, which involves definitely the knowledge in the subject of finance, which a lawyer may not be having. So he is accompanied by a technical member, and he is supposed to be, I'm saying supposed to be, a financial expert. And in case he is a financial expert and the person who is a judicial member, he is having a fair knowledge of the company law or the IBC, it makes a very good combination. The author of the law, the legislation, has very rightly determined this kind of arrangement on the bench. So definitely this requires to be looked into by those who are in the process of the appointing the members. And the second, the thing comes the timelines. As it's very often said, it's very easy to lay the timelines but difficult to follow. We must understand the practical the situations, I would say, which we face day to day while while deciding the cases or hearing the cases. And at times the lawyers are not there, and somebody says that he's busy in honorable high court, he's busy for honorable supreme court, so kindly adjourn it. Sometimes the lawyers are suspending the work, there is no work. But different situations everybody knows. So that we have to think the timelines very realistically, and it will not be out of I will not be I'll be saying that once the honorable supreme court said that 3:30, they said we can go beyond that also, but those are very exceptional situation. That should not become a rule in a routine manner. At times we may come across with the orders which are just passed in the extending the time. But in my experience, I have faced that there should be some definite reasons for granting the extension, and of course the maximization of the value is the primary the object of the legislation. But as has been observed by the Honorable Supreme Court in Jet Airways also, with the passage of time, even the liquidation value will come down. So timelines are absolutely necessary. It may not be mandatory, as been observed by Honorable Supreme Court, but they have a sanctity. So these are required to be observed by the NCLT and the NCLT. And for except, as I said, I will repeat that for any extension, it should be based on some very exceptional circumstances and very solid reasons. So these are the other thing which the Honorable Supreme Court has perhaps asked the concerned the stakeholders, I would say, and regarding the infrastructure. Infrastructure would not only mean increase in the number, and they have said it that organizing the refresher programs. I have seen the honorable the High Court judges have a judicial academy in Madhya Pradesh. Probably Mr. Makheja, it is Jabalpur, or it's a, because we see many honorable High Court judges. They go for periodical trainings even at this stage when they are the senior judges. And similar, there is a provision for district judges. The states, the high courts have their judicial academies. They conduct periodic program. They refresh them, but we do not have any such forum in the NCLT or the NCLT where there should be it is always when there are conferences, there is a brainstorming, there are interaction, people come with the ideas, and these things develop. We must have some kind of a platform or a institution like Judicial Academy, and I think that is in Bhopal High Courts. And as has been said, that we want the economy to grow. For the growth of economy, we require the capital. The more the infusion of the capital will be in the market, there will be stress assets. So things have changed over time. Now the investors want not only the easy entry, but they want easy exit also. And for easy exit, this law has been laid down, and rather, I would say, it at times the critics have their own views, which may be correct to some extent, that over the time this has worked more of a recovery forum rather than the insolvency. Particularly when we see the case like a Jet Airways, why it could not succeed despite it being a very successful and a functional airlines in the country. And the airlines in India, there is a huge demand of the airlines at present, and why it could not really go. So these are the few suggestions. Rather, I would say I have taken this, as the Honorable Supreme Court has also suggested, and the NCLT and the NCLT, have to take note of these, and try to reduce the time of because we feel delay is the villain. I would use the villain of achieving objectives of this legislation. So with these words, I'll give it to the moderator for having a session with the other members. Thank you so much.
Thank you, sir, for your suggestions and your views. Now, I think Mr. Prasad is there, our guest speaker. Sir, are you there, sir?
Yeah, I'm here.
Sir,
Brother,
I
you're
would.
there. Brother is there.
Yes.
Yes.
Yes,
I
yes.
would
He is
request.
he is the most experienced member. He was the last one to go, so he is the most experienced.
Wow, nice. So we are very delighted to have him here then. Sir, Prasad sir, we would request you to please share your experience as a NCLT member. And also, we would request your suggestions for improvement in NCLT working.
Definitely, definitely. In fact, let me thank the organizers for bringing this IP network. And in fact, I feel it's a wonderful, there's a wonderful attempt and effort being made by all of you. And as far as the Jet Airways judgment and the shortcomings and suggestions are concerned, let me start like this. स्मृतिः श्रुतिः सदाचारः स्वश्च प्रियमात्मानं सम्यक् संकल्पजा कामः धर्ममूलम् idam श्रुतम्. The very fundamental source of law from Manusmriti, it is said, Smruti, Shruti, Sadachara, Swasthata Priyamatmanam, something done with a good intention. Swasthata Priyamatmanam Samyak Sankalpaja Kramaha, something done without anticipating a kind of quid pro quo. These are the fundamental sources of law. Smrutihi Srutihi Sadacharaha Swasthacha Priyamatmanam Samyak Sankalpaja Kamaha Dharma Moolam Idam Srutam. These inputs are there in our IBC. Only I am now not analyzing due to shortage of time. IBC is a very good piece of economic law, and especially for a person like me who has a banking experience from the Reserve Bank of India, I was really appreciating the way each provision has been drafted. And actually, the shortcomings and suggestions, no father will say his son is up to the mark. No father will openly acknowledge that son is all right in all respects. So tendency of the father is to say, you have to improve here, you have to improve here, you have to improve here. And this is my suggestion. So here we have to take Supreme Court as not a real critic, but we have to take the role played by the Supreme Court as a father who is trying to bring a kind of improvement in the shortcomings which they have felt and the suggestions for their improvement. In fact, law is very wonderful, but law has to be made wonderful by all the stakeholders. Kindly appreciate that law is beautiful. It needs to be made wonderful by all the stakeholders. Neither the adjudicating authority, nor the lawyers alone, nor the other stakeholders alone cannot bring a revolutionary change in the working of the legal system. It should be always a unified effort. And basically, this is a new law which has come into 2016. Neither other than NCLT, none of the courts are constantly dealing with this law. They are dealing occasionally when it is getting a character of an appeal. And appeal perception always differs. What has been appealed is the criteria to decide whether appeal is to be allowed or not. Therefore, the criteria differs from that of the original jurisdiction, from that of the appellate jurisdiction. Perception also changes. See, evening 4 o'clock, you are going to the market. You don't wear a sunglass. But you are right from morning 10 to 4, you are in the sun. you will wear definitely a sunglass. So the perception of the members of NCLT, according to me, is really excellent, because they are the people who have molded this law. And these people are not just taken from the market. There is a process where the Supreme Court Chief Justice or the nominated judges were the selection committee members. So we cannot say that the members of the NCLT have not had enough legal knowledge. That I don't agree. Secondly, a law student is a student forever. A law student or IP. In fact, I say IP is also has to study the law regularly. So he is also a student forever. So it is for us, how do you study the law and how do you put that whatever you have studied into the practice, it is left to your own skill. See, there may be in a bar many lawyers, but few lawyers like Makija have made their mark. Why? Because they put an extra hour of hard work. So according to me, neither the members nor the system is at fault. But we are all have to make a combined effort to strengthen it and improve it and make it a better working system. See, this law has come 2016 itself, and it took initially for 3 to 4 years, any journey, to get it to a settled position. And the first batch, the judgments which the first batch have written, and the second batch and third batch have written, have created the basis and have created an edifice for this economic insolvency jurisprudence. Resolution is a new concept. Earlier, the law was confined to Presidency Towns Insolvency Act, Provincial Towns Insolvency Act, and if a person, and also the provisions under Companies Act and Partnership Act, where the liquidation provisions are there. So if a person is not able to do business, he has to go out of the business. But this law is said, if you can't do your business, give it to that person who is going to do it. For this process, they bought a new player, the insolvency resolution professional or IP. What I'm trying to say is that this law is still evolving, and shortcomings may be felt in a particular angle. But law is very good law, and the members are really brilliant. None of the members, all the members who are coming from technical side are IAS and IRS officers, are mostly from chartered accountants, cost accountancy profession, or from IP field. And these technical members, they bring some kind of specialization with them every time. And it is for the judicial member who is the, who is the commander of the court, has to draw what information he has to take from technical member and see that system gives the best judgment. And legal perception is always linked up with, see, what is exactly the law? If we speak for a moment, the law is a true representation of the socio-economic, political, technological conditions of a country. And the country's intellectual capacity in addressing such socio-political, economical, and technological problems. Why IT Act has come? Because we got the problem of technology. Why IBC has come? Because we want to show to the entire world that doing business in India is very easy. So we have codified the existing laws. And the approach of the members of IBC, members of NCLT, according to me, there is no straight away any deficiency. If one has to master, he has to put his extra hour. If anybody want to master a particular subject, that person has to put extra hour. Whether there may be a training college or whether there may be a training institution or not, you have to gear up yourself. Suppose you are driving with your wife and your wife says you are going very slow. What you will do? You will increase the gear and try to go faster and with all safety precautions. Like that, one has to gear himself. So the members have to put, if the members have to put a extra hour, they have to put. Secondly, there is a lack of infrastructure. This being a new baby born, the system is yet to be developed to take care. See, the staff who are working in NCLTs, all are borrowed hands. And there are no regular staff. When you don't have regular staff, you will not have accountability. And these people will come for 3 years, 4 years, spend here and go back. So NCLT should have a regular staff structure. And we don't even have sometimes proper facilities. You do not even get a right person to take your dictation. You have to train them. Again, that process takes place. So there some kind of infrastructural loose networks are there that need to be tightened. Secondly, in order to make IBC an effective legislation, advocates should discourage their clients to file false and frivolous applications. Many times, some frivolous application is being filed in the process of gaining time in the procedure. That advocates should discourage. Even there are cases where IPs also file some applications. IP should very, very rarely file application. According to me, an IP should only very rarely file an application because he is an officer appointed by the court. A task is given to him to discharge his duty within the framework of law. In fact, according to me, he is the officer appointed by the court and he need not have to file a specific application, engage an advocate, increase the expenditure of CARP or liquidation process. So there some kind of fine tuning at the IP level also. And the suggestions given by the Supreme Court are very aptly given. I told you now, kindly don't take this Jet Airways judgment is complete black mark on IBC. No, on NCLT or implementation of IBC. It is like a father suggesting to his son, because no father will appreciate the son's work. Father will always try to guide the son to become better. Father will try to first groom the son to become good to better, and to next the best. So whatever Supreme Court has suggested, that is in the light of becoming National Company Law Tribunal or Appellate Tribunal a best institution. For that, what we have to do? There are two things. One is internally the National Company Law Tribunal has to be strengthened. Its operating system within the eco-environment given to it, that need to be strengthened by putting proper person at proper place. And so-called the managerial concept of planning, organizing, directing, and achieving the final result has to be properly streamlined. And members are excellent. In fact, our Kapoor, my earlier speaker, has written very good judgments from Calcutta. Though by modesty he says, I'm not able to understand certain issues, I don't think so. By the time he has joined with us, he was a designated senior counsel. If the designated senior counsel doesn't understand, who will understand? I don't think he has spoken truth. And counsels like Makija has to be in the council side only. They should not become the members, because we learn many things when they come and appear and argue before us. Because they have to serve to the larger sector. So I suggest that those councils who are already from the beginning of IBC be in your profession. They need not become judges or members. Who has to become members? People like me have to become members. Because we have given certain judgments, we have made and molded the law, which is today has become inspiration. See, out of 100 cases, one case going to the Supreme Court or a higher court, or see, our system of hierarchy provides for appeal. So, those who feel that they have a strong case, their case could not be properly appreciated by the tribunal or appellate tribunal, can always go. And there the court may observe from a specific angle, nothing wrong in it. But as you said, when you wear a shirt and go to the market, all people says it is tight for you. Then you have to think how to make the shirt loose. Like that, certain kind of observations will be there by higher courts all the time. Not only in NCLT matter, there are cases where in other tribunal matters also observations have been made. Of course, these observations have to be taken as a guiding principles for us and strengthen the law and law adjudicating people. In fact, according to me, NCLT is basically constituted for the purpose of dealing with the company law cases. But
Yes.
it was asked to adopt another child, that is IBC.
Yes.
So I have to take care of originally born child as well as adopted child. And adopted child all the time cries, I want milk, I want milk, I want milk. And original child also cries. So where do I stretch? So somewhere I have to strike some kind of balance. And that balance may not be to the satisfactory to the others. See, IBC enormous cases filing is there across the country. Enormous workload is there. Actually, some time back, IBBI was suggesting to have special adjudication benches for IBC. In fact, that is correct. According to me, there could be some kind of segregation of the work. Some benches should exclusively deal with IBC. Some benches should exclusively deal with company law. Then the pressure of adopted child and a naturally born child can be reduced. Then system can be better streamlined. Then you see better judgments will come. See, if a cook is given half an hour time, if a cook is given half an hour time to prepare 3 to 4 dishes, can you assure the quality of those dishes? You can't. What I suggest is, my first and foremost suggestion for improving the working of NCLT is make separate benches for IBC and make separate benches to deal with company law matters. My second suggestion is that as far as IBC is concerned, try to constitute benches only with the judicial member. No technicality is much involved. And wherever technicality is involved, a single judge bench should recommend for constitution of a division bench, then the technical member can be given. Because the moment IPC, according to me, is basically a science of format. IBC application, you need not have to write any technicalities. As far as the IBC application is concerned, you have to fill the prescribed format. And you have to fill the prescribed format and submit. Until IP is appointed, no technical issue is prima facie involved. IP professional is always a chartered accountant or a cost accountant or a qualified business administrator who also has an edge of finance. Therefore, according to me, if you ask my sincere suggestion, my first and foremost suggestion is single judge or single member adjudicating authority who has good legal knowledge is enough for dealing IBC matters. For company matters, amalgamation, absorption, reconstruction matters, or payment of dividend, shareholders' interest, all those things, you may require some kind of good accountancy knowledge. There you can keep both judicial and technical members. You see the success of IBC where you put one single judge, because entire IBC is a format science and regulations are so perfectly framed. Each step is pre-written and each step is preconceived. Actually, I should say that this economic legislation is a format science where for each and everything a format is prescribed. Date of default, you have to enter. Amount due, you have to enter. This format science doesn't require the support of technical member. Rather, the technical member puts so many objections in format science. Says, year 3 ka बाद कामा नहीं आया. So what I suggest you is, in order to make IBC more effective, okay, I'll put up next slide.
Sir, we are not able to hear you. Prasad sir, there is some voice issue, network issues, I think.
It's okay now?
Yes, now it's fine.
See, what I suggest you is, I will suggest other things when we discuss with others. I think I have taken enough time. My humble submission is that at this juncture, IBC, for strengthening the working of NCLT as far as IBC is concerned, single member bench will be enough. Number two, let there be an exclusive court for IBC matters. And let there be an exclusive bench for company law matters. I will let others speak. Again, I will join at the end as and when you require. Thank you very much for the opportunity given to me.
Thank you, sir. Thank you.
Thank you, sir.
Your words of wisdom have enlightened us. Thank you, sir.
And I think, sir, we would request you to stay so that there are a lot of questions which will be there from IP fraternity, which we would like you to answer. But in the meantime, I think let our third guest speaker speak on that. So over to you, Tina.
I think Mr. Parag have to introduce third guest speaker. Mr. Parag, please unmute.
Yes, ma'am. Friends, it's my privilege to introduce Shri V. Nalla Senapati, a distinguished legal professional and former technical member of the National Company Law Tribunal. Shri Nalla Senapati served the High Court of Madras as an officer for over 2 decades, from 1993 to 2016, and notably as the official assignee for 3.5 years. After his voluntary retirement, he joined the National Company Law Board as technical member, serving with distinction from 2016 to 2021. Currently practicing as an advocate, he was impaneled as an arbitrator by the Madras High Court Arbitration Center in September 23, and is also into mediation. With his extensive experience in judiciary, arbitration, and corporate law, we are honored to have him sharing his insights today. Please join me in welcoming Shri V. Nalla Senapati. Moderator, ma'am.
Thank you, Mr. Parag. And I will request Mr. Nalla Senapati to please share your experience as an NCLT member with us, and also suggestions for improvement in the NCLT working.
Good evening, everybody.
Good evening, sir.
Good evening, sir.
Good evening, brother.
See, today's topic, Jet Airways case. Somehow I am also connected with the case because I was part of the bench which has approved the resolution plan. See, at the time, there were arguments for several days, and the main issue at the time was allotment of historical slots. Jet Airways wants that all the historical slots to be allotted to them. It has also been, I think, discussed in Parliament level also. Some questions were there regarding this. And at the time, there were favorable replies. But when it was before the bench, the senior law officer of the central government appeared and told that we will consider it first. They told they will consider it. Then thereafter they told they will consider, and wherever the slots are available, we will give, because some of the slots were already allotted to some other airlines. So without the historical slots, the resolution applicant was little reluctant. Then somehow they were convinced, and they have accepted this plan. At the time itself, I have pertinently asked a question. Sir, see, there are some conditions precedents in the resolution plan. Actually, it looks like conditions precedent, but they are all condition precedents for arriving at the before the what is the date, appointed date or expected date. So within the date, these are all the things that they have to do. That the merger has to take place, then the aviation certificate has to come, Like that, there were some conditions. Then after several days of argument, finally the plan was approved. Subsequently, the Honorable NCLT Mumbai bench has passed an order in an application saying that the respondent number 1 has fulfilled all the conditions precedent as stipulated in the resolution plan. See, the bank says that they have not satisfied all the conditions and they filed application. NCLT held that they have satisfied all the conditions precedent. Then they went and appealed to the Honorable NCLT. Honorable NCLT issued several directions, including a direction that performance bank guarantee of 150 crores could be adjusted towards the first tranche payment of 350 crores, which was to be made by the respondent. See, the plan says they have to bring in 350 crores as a first tranche in cash. They could not bring it. They say that they have given some performance bank guarantee, and the bank guarantee should be utilized to the extent of 150 crores for the 350 crores, which has to be infused in cash. That is the issue. Then this went to the Honorable Supreme Court. Honorable Supreme Court said that previously there were some applications, and Honorable Supreme Court already held that they have to bring 150 in cash, but they cannot use the performance guarantee. So maybe see, already the resolution applicant, they have infused funds, so many things has happened. They have tried to, they have suffered a lot in getting all these aviation license, this thing, that there are so many licenses are there, then for international operation and all those things. And considering the facts and circumstances, NCLT has held that 150 crore performance guarantee itself can be treated as an satisfying the condition in the resolution plan. Probably this might have been done by using the rule number 15 of NCLT and NCLT rules, where it says if there is no law on the point and there is no statutory provision, NCLT and NCLT can use rule 11. Then when the appeal went to the Supreme Court, the first issue was whether there is a question of law in this case. See, only section 62 provides that only when there is substantial question of law, the Supreme Court can entertain an SLP. The Honorable Supreme Court held that they have referred so many judgments and finally held that there is a substantial question of law. If you read all those judgments, we can say that almost every point when the parties agree, this can be brought before the Honorable Supreme Court. So, see, the issue is they have to bring the money in cash. They have not brought it. They want some performance guarantee to be adjusted. So whether it is correct or not, this is the main issue. So the Honorable Supreme Court held that, see, when there is no statutory provision and when the resolution plan is binding and it cannot be modified or altered subsequently, NCLT or NCLAT cannot, by using rule 11, extend the time and give some concessions. This is the main issue, and it has been decided that they have not satisfied the conditions of the resolution plan, and accordingly the company is sent to liquidation. So on seeing this, the Honorable Supreme Court has given so many recommendations. They have referred to the insolvency and bankruptcy committee's observations, that is regarding the speed speed is the essence of the code, and then the commercial wisdom of the COC, etc. And they extensively discussed with the guidelines for the committee of creditors. That is the COC, member of the COC shall be objectivity, integrity, independence and impartiality, professional competence, etc., etc. So when we are in the bench, when we see the approach of the bankers, they will be insisting that their money should comes to them. They won't bother about the operational creditor or even other financial creditors. So this is the approach of the bankers. So the approach of the bankers should be give and take policy. They should have a give and take policy. But in many of the cases we have seen, they will be fighting it out like anything. But that should not be the case, because the government of India says, see, the resolution has to come. That's why they brought the IBC. Here, when you take the practicality, see, we have seen. Hello. Yes. See, I have seen several applications, even in Jet Airways case also, filed by this customs department. See, they would not have filed the claim in time. They will be coming after 1 year, 2 years of time, and even in some cases after approval of the resolution plan. I used to ask the council, we used to pass the same order. We will be, you are going to reject this application, but why you are filing this kind of application? What they are saying is, sir, the department is saying, the commissioner is saying, so we have to file application, get an order. Then in fact, some customs commissioner office has sent a representative to our Mumbai registry and asked our registrar, sir, we are filing so many applications, but every application is being dismissed by the bench. So we told them, sir, there is a time limit for filing this claim and all those things. You people have to be very careful. You have to see the newspapers, you have to see the advertisement. Otherwise, IBBI website, go to appoint an officer, let him concentrate on the IBBI website. What are the cases in which IBC petitions are admitted? In those cases, you immediately file your claim. We have seen the income tax department also same thing. They will be filing the claim after an inordinate delay, and finally they will be asking for the admission of their claim. So naturally we have to dismiss this application. So the government or the IBBI or income tax department and customs itself, they have to educate these commissionerates that they have to at least file the claim in time. If you see, there will be so many applications from these departments. If the departments are sensitive and if they are having an eye on this IBBI website and all those things, they can at least file their claim in time, and they need not increase the docket load of the NCLT. So the Honorable Supreme Court has given many suggestions. So already my colleagues have discussed all those things. But anyhow, I will also, regarding this transparency, there should be transparency in this filing, numbering and listing of applications. So applications which are coming first, they should be numbered. Of course, there will be some returns will be there. That should also be taken care of. And numbering and listing. As far as listing is concerned, they may take year-wise. Suppose if the case is filed in 2016 or 17, in a particular day, they say IP number is, insolvency IBC petition is in the year 16, 17, they should come chronologically. See what is happening is serial number 1, 2, 3, 4, 5, some orders are passed, and 6, 7, 8 adjournment is given. See, these things are listed in the same order. instead of listing in the same order, the cases of the previous year, earlier year, say 2016, 17, 18 cases, you should come in this order. Wherever the IBC or company petition is of the year 15 or 16, that should come first, so that automatically it gets priority. However, if there are some urgent cases are there, then urgent mentioning can be done in the morning itself, and it can be listed within 2 or 3 days if it is really urgent. So this listing, some kind of the system improvement is required. But my brother told that specified benches are required for specified benches are required for IBC and company cases. So that may also be tried at least as a trial basis. And then this regarding that communications with the regulatory authorities. Already RD, the ROC and official liquidator, they are all in, they used to come regularly to the court, and then and there they are telling their problem, and these problems are getting solved. See, then the age of the members, that selection of members above 50, I think the government can consider it reducing it substantially, at least to 40. And if 40, and then they should also be given some chances for elevation to high court judges, like that, so that younger people will come and join also. Then they will develop their domain experience. Then whenever members reserves the order, some time limit should be there. Otherwise, they should not reserve the orders, because reserving orders and keeping it for some time, there is a chance for forgetting the arguments. So then wherever there is a resolution plan is listed on a particular day's list, it should come top, so that at least approval of resolution plans will get clear. With this, I want to conclude my lecture. Thank you.
Thank you, sir. Thank you. We have many more questions for you once we hear our learned IP Narendra Kumar Sharma ji. Mr. Parag, can you please introduce him?
Yeah, sure. Sure, ma'am. Friends, it is a matter of honor to introduce Mr. Narendra Kumar Sharma, a seasoned professional with over 30 years of experience in corporate and financial management. Mr. Sharma is a commerce graduate with a fellow company secretary. Mr. Sharma has been an insolvency professional registered with the IBBI since 2017. He has extensive experience in company law, banking and finance, and legal operations, having served in public listed companies from 1985 to 2003, where he managed NPAs, debt settlements, and rehabilitation schemes. Currently, he is handling, among others, a complex real estate insolvency case involving over 2,100 stakeholders with claims exceeding 1,400 crores. Please join me in welcoming Mr. Narendra Kumar Sharma as he shares his insights on today's topic from IP's perspective. Moderator, ma'am.
Yes. I would request Mr. N.K. Sharma to express your views on the judgment from IP's perspective. Welcome, Mr. Sharma. Sir, you have to unmute yourself. I think, sir, you have to rejoin, because I'm also trying to unmute you, but I'm not able to do from here.
Yes.
Okay. Yes. Now audible, sir. Please.
Good evening, everyone.
Good evening, sir. Good evening.
I have been looking after IBC matters since 2017, and I have handled matters relating to steel industry and real estate matters. It was a wonderful experience dealing with in IBC matters. And in real estate matters, of course, it was a great challenging, and it came to me during 2019, At that time, I think it was one of the case with first case in the real estate matters, and all the problems, all it was new to each and everyone, specifically relating to claim settlement, verification and collation of the complaints. I hope everyone is aware that in real estate matters, you hardly get a record from the promoters. And specifically when the promoter is behind the bars, there is no one who is going to share the information to you. You are short, you are not, the financial statements are not available to you. Bank statements are not available to you at that time. And you have to, what is available to you is just a data of a list of the claims which IRP has received and whatever data he has maintained. Now, the first thing you have to do is to find out the data. In order to process the claims, you need audited balance sheet at least up to the date of commencement of the CIRP. It is very unfortunate, even the statutory auditors, they do not share any record with you. They are not ready to part any information to you. No staff of the corporate debtor is available to you. But somehow, as to discharge your duties under the IBC, you have to prepare the information memorandum. And here the problem starts. You don't have the detail of assets and liabilities of the company. So that is a big problem, how to prepare the information memorandum. But somehow then you have to look beyond the box. You have to collect all the information available in the public domain, and then you prepare the information memorandum. So based on, but if you prepare the IM without any confirmed information, that itself is you are inviting litigation, because there are a lot of stakeholders who are going to raise these points with you. So, but once you get the books of accounts audited, you start collating and verifying the claims. Again, that is a problem, because whatever the claims were provisionally given by the IRP to RP. And when RP will verify these claims, there will be a lot of difference, because at least in the real estate matters, number of problems, because the funding of the real estate matter is project is basically relating to the cash payments and payment to the promoters. Then the nature of transactions. There are some allottees for which CRM data is not available to you. Then there are clean funding cases also, which again is a problem, because all those who have made advance funds to the company, they have some kind of the documents available with you, and there is some element of allotment of any space to them. So that is a big problem. When the RP will collate and verify the claim based on the data, obviously claims are going to be reduced by the amount of cash, because there will be no data available relating to that. No receipt will be issued by the promoter to him as per the normal practice, but a receipt on the letterheads without clarifying the mode of the payment. So when coupled with all these problems, you have to issue the EOI, inviting the problem. Again, unless you have the complete details with you, you will find hardly any taker for the project. Now that will result into delay of the resolution plan, completion of the CIRP. And so far, this has been the experience, my experience in the real estate matters. That's all. Thank you.
Thank you, Mr. Sharma. Thank you so much for expressing RP's worries, concerns, and bringing it forward. Thank you so much. Now, we will be starting with question answer session. But prior to that, I will give a brief of Supreme Court judgment of Jet Airways in 5 lines only, just for my other participant IPs. Uh, Discretionary power. The observations of Supreme Court in brief are: discretionary powers must not be exercised mechanically without any application of mind. After all, such discretion cannot be exercised to the detriment of the resolution plan and its implementation itself. One of the reasons of supporting the grant of extension would be to ensure the successful revival of the corporate data. Multiple extensions may seriously hamper the economic feasibility of the resolution plan and also lead to an increase in debts of the corporate data. The discretion in extending the time limits fixed under the resolution plan must be exercised in a much more circumspect manner, especially in the cases when it pertains to aviation sector. Then fifth and the last observation, in short, where there exist extraordinary circumstances warranting the exercise of such powers in order to ensure that the very salutary purpose of the code 2016 is not frustrated, then the court would be well within its prerogative to exercise them to secure the object of IBC 2016. So these were the observation in short for all the participants, our audience IPs. Now I will proceed with the most interesting part for which everyone is waiting eagerly. I would request Parag ji to show our guest speakers at least. I'm only able to see Mr. N.K. Sharma. Can you change the setting, please? Is it possible?
Tina, you go ahead. Everyone can see you and they will respond. So please go ahead. Let's not waste more time on this now.
Okay. So I will proceed with the questions for the speaker to get enlightened, see the judgment from various perspectives. My friends, my fellow IPs, the session will be interactive session. We would also keep inviting questions from our audience IP. We'll try to take as much questions as possible. But the only request to all my fellow IP members is to pen down to the point questions. We will give them opportunity as and when possible. So we will start with our question session. Mr. Prasad, our guest speaker. Sir, are you there?
Yes, yes.
Okay. Sir, my first question to you will be, how has the Jet Airways judgment highlighted the need for reforms in the functioning of NCL?
See, they have gone through the process time that has been taken place mostly. Appears to be, to my assessment, they have gone through the entire case process time that has been taken place, and then they felt there is a need for speedy resolution process rather than the step-by-step resolution process.
Tina, if you can permit me, sir, there are few questions in the minds of the IPs, and I'll just take up one by one few of them.
Please.
The first one is, sir, there are the question which is the concern which is in the minds of IPs is that there is always a pendency of the applications, particularly the resolution plans. Resolution plans have been pending with many benches for almost maybe more than 1 year, in some benches for 2 years also. So is it not possible that we should, like Mr. Nala Senapati also mentioned, that priority should be accorded to the approval of the resolution plan? So what is your take on this, sir?
Yes. Internally, in fact, till my tenure, our president has given us an instruction that resolution plan should be prioritized and should be disposed of. And we too also used to regularly give priority to resolution plans. But the problem, lot of objection applications to the resolution plan. The objection applications which have been filed by various stakeholders are enormous in their number. I have seen in one particular plan 152 applications. So unless you knock out, see, it is like agricultural land, suppose assuming. Unless you take out those unwanted trees which have been grown up, you can't really take care of the main tree. The bushes have to be cleared. So the objection applications being enormously filed, whether the objection is an entertainable objection or not, Makija ji, आपको भी मालूम है, your clients would have been suggested you to file an application, बाद में देके जाएंगे. So these kind of applications, unless these applications are addressed, you can't address the resolution plan.
Sir, yeah, sorry. I'm so sorry, sir. Go ahead.
Either you should club all the objections. What I have done is, in one particular resolution plan case, similar kind of objections we have grouped and asked them to identify one particular advocate who represents similar kind of objections. And we heard them, disposed of, then we have accorded approval to the plan. So some kind of a member at his own level has to follow a specific approach. Or sometimes if the applications are one or two only, then along with the main resolution application, the objections can be heard. And first an order objection can be passed, and at the same time the plan can also be approved. We have done it. And resolution plans are given top priority, whether you believe it or not. And you know it. You know it, how many people file objection application. You are not new to the system. Actually, you should tell all the IPs, we have to ensure that minimum, see, if the IP takes care of right from the stage of RFP, very few objections can crop up. IP doesn't take care of the entire process right from RFP, then many objection plans will come.
Okay, all right, sir. I think your views are well taken. But the only problem which we can anticipate is how to control these applications. So my question to Mr. Rohit Kapoor is, based on his experience as a lawyer on the other side and also a judge on the other side of the table, how do you perceive this, sir? Because applications, everyone has got a right to file the applications, whether frivolous or not. But how to handle this particular topic, that these applications must be disposed of before the approval plan application?
Not required, Mr. Makeja. What we used to do it, we used to hear along with the plan, and with the passage of time, because being the HOD, I was having the data also, because we have to send it to MCA also and the president also. And see, over the time we have seen this tendency was coming down, because we were imposing costs, and that proved to be a deterrent to some extent. But this overall I saw in Calcutta, and there is a record for that, and this filing was less than the disposal. That the number is coming down. But as a lawyer, you can't really stop anybody from filing application, or because we don't have the much of the cost deterrent now maybe, but I think that overall there is a feeling among the IPs also. It may be costing, it may be adding to the cost, so avoid it as much as possible. There is a change, I see.
Right. Yeah. No, we appreciate that, sir. Mr. Nala Senapati, sir, there are admission applications also which are pending. So from the bench perspective, do you give priority to the admission application, or to the, say, section 19(2) applications, or to avoidance applications, or to approval of plan applications? Because everything is important. So what is the guidelines which is issued to the NCLT benches to tackle all these kinds of applications, sir, in priority?
Wherever resolution plans are pending, we have to give priority. And then Section 7 admission. It was like that 19.2 and all those things. We will be disposing it of within 5 minutes. What is there in 19.2? It's only a direction. Then these PUF transactions is really some applications. In one application, I think there were 150 respondents in Mumbai bench in one case. I think Mr. Kadam Senior Counsel was appearing. I told sir, what is this? How much time it will take to serve these people first of all? Then they have to come and file the reply counter. Then rejoinder. How much? Then I told them better you withdraw this application and file separate application. See, they are even transactions which are not connected. They will be putting 150 respondents, and then how we can pass orders in 45. See,
Right.
the problem is Section 45 and all those applications. I was an official assignee. At the time, similar application under Section 55 of the Presidency Towns Insolvency Act. There we have to give concrete proof. It's not just like that filing an application. You see, many of the application, they will say this is the provision of law. Then the money has been transferred. Even if he is not a creditor, they will ask, they have preferred the creditor. Many applications.
True.
All those applications has to be dismissed. There is no other way. When a person is not even a creditor, and they say he is preferred, then what is the velocity? I mean, merit in the application.
True.
I have seen even RPs, just like that, they will file those applications without applying the mind. But that is not correct. Maybe because they are all afraid that IBBI tomorrow will ask something, this thing, that kind of fear is there, I think.
Right. So I think, sir, the idea is, as Mr. Prasad also mentioned, that it is the work of all the stakeholders, including IPs. They will also have to gear up not to file frivolous applications, make sure that the process goes on smoothly. I think everyone has to contribute, not only from the benches side. So I think your point is well taken, sir. I think Mr. KJ Vinod has raised his hand, so we'll hear from him. Mr. Vinod, if you are hearing us, can you?
Yes, sir. Thank you.
Only request is, sir, be very pointed and ask a specific question. Go ahead, sir.
Yeah, specific question concerned to the discussion what is going on. Right. And I heard Narendra Kumarji Sharma ji as well as Nalavati Sir. Now you see, I'm clubbing in two questions together. We are a country where we landed in mood, but we don't have reporting system, especially by the corporate. Narendra Kumarji are telling that yes, there is no accounts data available to the RP, but especially this matter is come up. Why don't we make a system such that we have the information utility for those companies who are in the promotion of real estate, because they are playing with the money of the people of India? Why don't we have a certain set of report in the information system itself? Why there is a delay for the implementation of that? Because information is available, RP is able to do well taken the matter. Number one. Number two, Nalavadi sir, I come across a decision of the Mumbai NCLT not maintaining the books of account is amongst 66. Now I'm clubbing these two questions together. There itself, not maintaining the account and not providing the account by the statutory auditor, is it not 66 straight away? Question to both dignitaries.
Yes, first you have to try to get the information from the corporate data, then from the auditor, then you have to file an application. There is no other go.
Exactly. When we do this process, no, not the statutory auditor, neither the statutory auditor nor the corporate auditor is not maintaining any detail or not supporting us. Right. On the other side, as you stated, there is a sword from the IBBI. Okay. Now, how do we come across that? We can very well do it for sectorial report. For real estate, if a sectorial report is available on specified parameters in the information utility, that can be well taken.
Mr. Vinod, I think your question is more on the information
Academics.
ability. We are talking here about the efficiency of NCLT because the NCLT can only pass orders once you file application under Section 19(2). What we have given a suggestion to IBBI and also MCA from IP Net is this, that the movement, and I think this is something which I'd like the comments of all our guest speakers here. There is a provision in the Companies Act which was there in 2013, which when it was amended, that before once a winding up application is filed, before a reply chance is to be given, along with the reply, the company is supposed to submit the statement of affairs, detailed statement of affairs, and also tell the court where the accounts are located, who is in possession of that. Now that thing has not been reciprocated in IBC. So my suggestion was to the benches and also to the MCA that please amend the law that the moment Section 7 is application is filed, notice is issued to the corporate debtor. The corporate debtor, while replying, should also file a latest statement of affairs so that at least the latest data is available on record. And if they do not file, then their reply should not be taken on record. In fact, this provision is there in the Companies Act 2013. Why it is not replicated? Well, that's a question which need to be asked. So this will actually smoothen the process. And
No, that's right. That's right. The problem is, if you ask for more details, they will see even reply they are taking time. Then rejoin. If you ask for the account, it will take further time, and the time limits cannot be added to. It cannot be met with. That is the problem.
So the only point is that at that stage they will submit every information, but after you see their case is admitted, all the directors abscond. I mean, they do not cooperate. So all I'm saying is, even if there is a 10-day delay in submitting that statement of affairs, it should be fine, because at the end of the day, sir, admission applications are still taking 3 months to 6 months time in any case, sir. So that is the only suggestion which was given. I think we can have comments.
Yes, Mr. Makeja, it really, you know, it sounds really good, and it should be there, and it can be put to test, because we have faced many situations on 19.2. Because in 19.2 a word cooperation is used. It was a law, you know, not thought to be so adversarial as it has become today. So we call the Director General also, we should be bailable warrants, non-bailable warrants. But this, I think this can be some, this really requires consideration.
Actually,
this requires a thoughtful consideration.
Supporting the views of Mr. Makeja as well as my friend, what I suggest is, let us suggest to IBBI to incorporate a suitable amendment in their existing regulations regarding submission of latest financial statement,
along with the written statement,
along with their reply. That will serve some purpose.
Correct. I think we'll take now questions from Mr. Ravindra and then Mr. Prateek Sarkar and then Mr. Ravinder Chaturvedi.
And Mr. Makeja, sorry for interruption. There is a conference which is coming up in Delhi.
Yes, sir.
And probably there is a member, the Secretary MC is also coming.
Right.
I would like to, if I get a chance, I would like to.
Sure. Absolutely, sir. Mr. Ravindra, yes, go ahead, sir. Yeah.
Good evening, to everybody. See, one of the things is, see, when the statutory auditor is there who is auditing the accounts, he should be well aware of all the state of affairs of the company. We should make the responsible the concerned auditor who has audited the accounts to give all the information. What is happening is the promoter does not cooperate with the auditor to give the information, and the auditor also he will make this thing. Because as per the Companies Act also, it is the responsibility of the auditor to verify all the things before giving the certificate. Suppose we make him responsible to see that the data is given even without going to the NCLT, giving a direction and all of these things, that will save some time.
Mr. Ravindra, let me answer this question from a chartered accountant perspective. See, as far as the statutory auditors are concerned, they are not supposed to have the complete data. They have only audited. They have their own working papers. They don't take entire data from the company. Please understand this. So if you want an audited balance sheet which is not available on MCA website, yes, they should submit it to you. But if you expect that they should give you entire tele data and the all accounting records, I don't think they will have it, sir. So there
they
is
don't.
purpose, though no purpose will be served by putting this kind of a provision.
No,
Okay.
they are the books of the client, and books of the client have to be returned to the client.
Yes, correct, sir. Correct. So, Mr. Prateek Sarkar, you go.
Yes, sir. Yes, sir. Sir, I refer to the incident which Nala Senapati sir was referring to.
Before you ask your question, if your question is directed to specific speaker, please name that so that they can answer it.
Actually, my question is directed to all the learned tribunal members present with us. I refer to the incident which Nalapati sir was referring to regarding the number of respondents in a PUFE transaction. Now, there is a provision in NCLT rules of Rule 61 of appointing an amicus curiae. Now, whether it be an application for Section 19 or whether it be an application for PUFE transactions, now, is it a workable solution that an amicus curiae be appointed to look into the intricacies of the transactions which is alleged, then present a report, and basis that report the adjudication to take place? Is it a workable solution? My question is to all the learned NCLT members. Is it a workable solution?
Enabling provision, that is wrong in tapping it and utilizing it. But how far it becomes effective, that cannot be decided today. As you rightly said, it is a kind of indirect delegation of NCLT work to amicus curiae. It can be encouraged provided the enabling provision really supports such kind of delegation. Amicus curiae actually has to come as an expert, and he cannot really do that job which the tribunal is expected to do. The very concept of amicus curiae, Makija will be able to give you more clear picture, and I can also give you, but only the thing I speak it in a very lengthy way. Amicus curiae role, concept, is subject matter of interference is very limited. Not as you think, he cannot be a real substitute for the work which NCLT is supposed to do.
Correct. And in fact, sir, amicus curiae concept is to be taken on an exceptional basis, where there are certain complicated questions of law arising. So then the court can take help of some outside.
Sir, if I may add one point to that. Sir, if I may add one point to that, now having argued in such matters, what we generally do is that the evidences are not specific on what are the charge against me. So the people start introducing the criminal jurisprudence into it, that if I'm alleged of something wrong, the charges should be specific. What I am saying is that let at least a body be created who will give an opinion that basis the document, this is the conclusion. Of course, it is finally up to the decision of the learned members. I'm not saying on that part, but I'm only saying to uncover the financial intricacies to at least establish on the charge for Section 19 or a PUFE transaction. In that respect, my question is.
Sarkar, I think let's hear from Mr. Kapoor on this now.
Yes, sir, Mr. Makeja, I was just thinking about the last one. Even assuming there is no provision as such that along with the reply they will produce certain documents. But I not having copy of the rules, but there is a provision in the rules, like in the Code of Civil Procedure. The court can ask for the production of certain documents, assuming the financial creditor, while moving this petition, moves a small IA, that along with the reply they may be directed to produce these documents. So instead of waiting the change in the legislation, if there is small application in the, along with the financial character, I think that can. I don't think that.
Yes. Sir, the NCLT
that is one
powers,
of the
powers of NCLT are not, you see, limited. They are very expensive, and they can also use the powers for production of documents.
But there is a specific regulation, rule in the NCLT rules.
Yes, Rule 43 of NCLT rules, sir.
Yes, there. I don't recall. Yes, Mr. Prasad, there is one.
No, that's okay. What I'm trying to impress on. Yeah. Yes. No, see, what I'm trying to say is, if you ask them to file an application, they will file an application opposing the same. Again, one meeting has to be given.
No, absolutely right.
No, the accounts thing, which is the non-cooperation we face a lot subsequently. 19 thing.
Anything can be done as long as the basic parameters of law. If the adjudicating member is satisfied, there is a justification for the reasons recorded in writing. He can pass a speaking order, asking the party to produce the same.
True, sir, true. And I recall, sir, before your benches, when I was appearing, you were the first ones to issue the bailable warrants and non-bailable warrants also under
Yes.
Section 19(2) also. So I think
Yes.
the process has actually been smoothened out. So I think IPs need to be very sure and file applications immediately if they don't get the cooperation. I think now we'll go to Mr. Ravindra Chaturvedi, who has been waiting very patiently. Yes, Mr. Chaturvedi, please go ahead.
Sir, my question is with Mr. Senapati, sir. Vanakkam, sir. My question is that since almost you have rightly said the IP in the fear of some IBBI this pressure, they filed the PUF application without sometime application of mine. But the ground reality is, sir, 2 lakh crore, more than 2 lakh crore case are pending, which is still to be resolved. And in many cases, even the resolution plan is passed, liquidation is got over, and still they are still pending in the court. So one should look into that point of view also, that IP is working hard and they are just trying to perform their duties. But the most of the time, the IP feel that just date is being given and the case is not even heard. Even the respondent is not filing the reply. So what can we do to early resolution of these cases?
Early resolution of these cases, I will tell on behalf of Mr. Nala Senapati, brother, give me your wakalat.
Yes, brother, always, no problem. You can proceed.
When such kind of application has been seen by the member can stipulate within a specified time the reply need to be filed. And if they don't file, he can straight away in the first order itself say, if you don't file reply within a week, heavy cost will be imposed not less than 2 to 3 lakhs. Then reply will come within a week. Then it can be disposed of. I have done it.
Okay. Or ex parte order can be passed with the directions.
Brother, ex parte orders are criticized well.
Okay.
See, canon of principles of natural justice will come. Ex parte orders should be rare and rarest of choice, that too for recording the reasons.
Right.
True.
Right.
And the person
Party order just passed.
And the person against whom the ex parte order is passed, he'll go in and appeal, and the entire thing again will get delayed.
Yes.
No, actually, that's only we discourage passing of ex parte orders. But in 1 or 2 circumstances, we will give an interim ex parte order.
Right.
Suppose in a case where Makija really convinces us, and we will also get convinced because of his logical reasoning, then we will say granted ex parte interim order till 1 week, and within this 1 week reply has to be filed. We see NCLT members are trying their level best to foster the objects of IBC in a judicious adjudicatory matter. In a judicious adjudicatory manner. We are judiciously adjudicating the issues before us, and wherever there is a requirement, we never hesitated to pass an interim ex parte order. I have passed.
Correct. Yeah, we have seen that, sir. We have seen that. So I think, Mr. Chaturvedi, you must have got your answer. Now we'll go to Mr. Kabir now. Yes, Mr. ML Kabir. Yeah, please go ahead, sir.
Yeah, Ramani sir, my question is, you made a couple of suggestions to improve on the efficiency and the speed of working at NCLT. And one of the suggestions was that there should be a single judge bench and the technical member may not be there. You see, as a person, as an IP, the question which comes to my mind, would it really not increase the work? And we have to have more judges as judicial members there, because, the workload apparently would increase if the technical member is removed. And the next question also, yeah, I mean, did I understand it correctly, sir?
No, you understood it very correctly, but it requires a small fine tuning.
Yes, sir.
See, when members are less, I advocated the concept of designating a particular court as, and keeping the present scenario in view, a dedicated court of single bench can be for IBC matters. See, as a IP, this would have been your experience. Entire IBC is nothing but format gaming. If you fill all the formats with accurate detail, nobody has to take an extra effort to pass an order in your favor. And if it is supported by the relevant data wherever the context requires. See, there are applications where the date of default is never defined, especially in case of financial creditors. Some financial creditors takes date of default is the date of NPA. Some people will take 90 days after NPA. And some people will not define any date. They will write 10 dates, date of default. How do you conclude date of default? So these things have to be defined.
Okay, Mr. Kabir, if you don't have any other follow-up question, we have to actually move a little faster now. So do you have any other?
Sure, sir. Sure, sir. No. Actually, the second question also was connected. He has touched upon that for a special courts for company law and IBC separately. The question was the number of people have to increase, otherwise this kind of a structure may not be really working, So this is what I felt personally. I don't know what would be the others' take on this.
One thing I tell you, what is workable and what is not workable can only be adjudicated when it is put into practice. According to me, this is workable because I worked as 5 years as judicial member, and there are cases where technical member and judicial member doesn't come to one conclusion. They pass two different orders. Such number of matters I have dealt with, where I was single member, third reference, and I have passed orders, patafat. See, what I'm trying to say,
thank you.
If your object is to get adjudication as per law within the time framework, there should not be multiple adjudicators in one matter.
Right. So your point is well taken, sir, that these are not very highly technical issues that are involved in IBC. So therefore, a single judicial member can take it up, sir. I think your point is well taken, sir.
Judicial member strength can be increased. What is wrong in it?
Right. I think Mr. Binay Singhania is also waiting patiently. Binay ji, please go ahead quickly because we'll have to wind up now. We have already exceeded, coming to 2 hours now. So please go ahead. Yeah.
My question is to Mr. Prasad only. Yeah. So regarding this IBC, when I touched upon this IBC, I had studied for BLRC. So the prime theme of the IBC is it is different from the other law. The basic theme is the SSR of India, and whatever SSR there, that should come to use. And if the promoter is not in a position to use it, then some other person should start the company afresh. Now, even when a company is taken into IBC under Section 7 or 9, then what we have seen in many of the cases, in most of the cases, I can say that lots of time is passed. some rejoinder is to be required, some reply is to be required. Thereafter, the major issue comes for settlement. And I have seen in some of the cases, 2 to 3 years have gone only for the thing that settlement is going on, and by the next date settlement will be there. So the basic theme of BLRC is when the IBC process is started, as soon as the default is clear, the company should come into this one, and faster the company should come into IBC, the faster the other person will be in a position to start the company, and the maximization of value would be there.
Okay.
And I have seen,
I think we have understood your question. Your question relates to that the time should not be given for settlement the moment the default is there, so bench should admit it. I think that is your crux of the question.
Only one more question. When we have only 3 criteria for the admission, then why should we go for another criteria, right? Default and company and 1 crore. 3 criteria are there. The judicial member or technical member should see whether these 3 criteria are met or not. So that's the thing. Mr. Prasad, please.
See, again, you are raising 2 issues together here, according to me. One, you are saying, why don't there be simply passing off an order by taking the debt and default and the monetary criteria without giving a chance of hearing to the respondent or the corporate debtor? That is your first issue. Am I correct?
Yes.
Yeah. But
yes, sir.
Yes, you know Bombay blast case. Bombay, that terrorists have openly fired, and the terrorists have been openly seen, and the terrorists have been arrested, and the trial was conducted for 3 years. Why? To comply with the very concept of principles of natural justice. See, law says justice should not only done, but undoubtedly and perfectly seems to be done. So, opportunity to the corporate debtor has to be afforded, and his version has to be heard. Suppose if the financial creditor approaches with concocted documents, if the adjudicating authority closes its eyes and passes an order, it will not be a meritorious order.
Okay.
Not only meritorious order, brother. After passing the order, they have the chance to go to NCLT. After completion of the process, the order go to NCLT and it gets overturned, and thereafter it may go to Supreme Court and overturned, right?
I think, sir, that is understood that the chance has to be given, but his second leg of question is that too many chances are given for settlement also, which
I will tell you why too many chances are
time limit can be fixed. That's all.
Generally, we don't give too many chances. In principle.
Why particularly the State Bank of India should file applications for seeking main lender? They file applications.
The Corporate Debtor Council as well as the Operational Creditor Council or Financial Creditors Council both will come and say, sir, there is a possibility of amicable resolution, afford us an opportunity. The next adjournment they come, sir, negotiations have been halfway successful, first round of sittings are over, kindly give us another 10 days. Then they will say, sir, he has paid out of which 10% initial payment and he wanted further time for payment of 80 to 90% in 3 slabs over a period of 9 months. Kindly grant us. Do you think really if a person is just due to a specific circumstance unable to pay, immediately you adjudicate upon him and you say that his organization should be subjected to CARP, or you should give him a little chance of meeting his debt obligation. So sometimes what happens, the bank himself comes and says, OTS proposal is pending. Our advisory committee or top management has to look into it. Kindly give 1 month time. See, delays, Makija will be the best person to tell how the delays will take place in our NCLT. It is not that the adjudicating authority gives. When both the parties comes with a different kind of pleas, justifying that particular movement why they require little time in the matter, we have to adopt some kind of human approach also. So those cases get little time.
Right.
Generally, the moment OTS proposal is pending, we say that we will dismiss this application. In case the OTS is not resolved, then come to us. That is the practice not followed in Delhi. The moment the adjudicating authority comes to know OTS application has come and parties are going to for OTS settlement, the councils are only requesting. Otherwise, we don't grant.
So typically, sir, these provisions are being used as pressure tactics, and even bankers, like Mr. Rohit Kapoor also mentioned, that even the bankers are also filing and taking time for settlement. So this was not the idea behind IBC.
Banker files an application under Section 7 and banker also entertains his OTS proposal.
Yes,
Why
yes.
should he do that?
Correct.
Either he should go with Section 7 application or he should go with OTS proposal.
So I think, sir, there is a slight dichotomy because Section 7 and Section 9 says that the default must be determined in 14 days, which is not possible because of these applications also.
No, Mr. Makeja, otherwise, please see. 14 days. See, you have, perhaps there's a US legislation. 14 days time practically. We know our realities.
Absolutely.
We know our ground realities.
Absolutely.
In fact, our NCLT, as early as in Raja's case, observed 14 days is not mandatory, but is only directory in nature.
Correct, sir. So I think, sir,
the practicality has to be perceived depending upon the facts and circumstances. But I am assuring you, my dear learned IP, adjudicating authority would like to decide Section 7 or Section 9 application, including Section 10, as early as possible. Only because of the council's approach, because of the creditor approach, and the corporate debtors approach, we are bound to give them little kind of accommodation. Otherwise, we from our core of the heart, as adjudicating authority, doesn't want to stop firing our adjudicating orders.
Absolutely, sir. Absolutely. I think, sir, we have got wonderful views. I think now Mr. Chatkara can take over and complete other, the closing processes, please. Sandeep?
Mahejaji,
Yes,
before
sir.
that, what are the steps we are going to take from IPNet platform on the matter we are discussed regarding NCLT and all those things? I hope you maybe come back with.
We'll definitely do that, sir. Whatever suggestions.
And I also request you, sir, have a special program on the MSME. There are many problems are there.
Mr. Vinod, we are circulating one. You will get an email or the WhatsApp group. We are taking suggestions for the program, so we'll talk about on that offline, sir. Okay.
Thank you, sir.
Sandeep, can you please do it now, because we don't want to overshoot time.
Yes, sir. So this has been a wonderful session, and I thank all the eminent guest speakers for taking their time out to share their enriched knowledge with us and making valuable contributions to this highly knowledgeable webinar. And now I would like to request Mr. Parag Singhal to display the memento to our eminent guest.
Sir, as a token of respect, sir, we are displaying the memento on screen. We request you to accept it, and we will send you the physical copy later on, sir.
Thank you so much, Mr. Makeja.
Parag, please go ahead.
Thank you, all the guest speakers of the day. We truly appreciate that you have taken out time to share your enriched knowledge with us. Please allow me to display the mementos. Thank you, Shri
Oh,
PSN.
grateful.
This is
It's nice.
Can you go back, Parag?
Yeah.
This
Yes.
this is for Mr.
Thank you so much.
This is for Mr.
Yes.
PSN Prasad. We'll request him to accept it with folded hands. We request him to accept it.
I accept it with pride.
Thank you, sir.
Thank you very much.
And now this is for Mr. Rohit Kapoor. I think
Thank you so much. Thank you so much.
we'll send you the hard copy, sir. And
Thank you so much.
Parag, this is
I'll be honored.
This is for Mr.
Thank you,
Dada
sir.
Senapati. Yeah.
Thank you.
Thank you, sir. Thank you. And for Mr. Narendra Kumar Sharma.
And last but not the least, sir, our
Right.
thanks to our moderator, Madam Tina Saraswat Pandey,
Thank you, sir. Thank you.
conducting this session in such a smooth manner. Thank you very much.
Thank you.
Yes, sir. Thank you.
Okay.
Now actually going forward, so I would like to say that IPNet will continue the journey of learnings by organizing such knowledge sharing webinars, and so we will try to maintain the frequency of the same. And I would like to invite Rashmi Chachwaria ji, Mr. Vivek Chirania, who is actually IPNet East member, for announcement of our next webinar.
Thank you, Sandeep ji. We are excited to invite you all to our 12th webinar scheduled for 23rd November 2024 from 4 p.m. to 6 p.m. And the topic will be managing attachments, interplay of PMLA, PF and IBC. And our esteemed speakers will be Mr. Narayan Kamma, Additional Central PF Commissioner and also an IPNet member, and Mr. Vinay Kumar Singhania. He is also an IPNet member and an IP. So join us for an insightful session exploring the nuances of the Prevention of Money Laundering Act, Provident Fund, and the Insolvency and Bankruptcy Code in managing financial and legal attachments. Stay tuned for registration details. We look forward to your participation. Thank you.
Thank you.
Thank you, Vivekji. Thank you so much.
Thank
and
you.
All the very best to you for this very webinar. And now I would request Rashmi ji to give a formal vote of thanks.
Good evening, everyone. I am grateful to IPNet for the opportunity to deliver this vote of thanks. Today's webinar on enhancing NCLT functioning, insights from the Jet Airways judgment has been truly enlightening, addressing the critical issues in the IVC ecosystem that demand attention and reform. My heartfelt gratitude to our esteemed guest speakers whose insights and practical experience have greatly enriched us. I also thank our session moderator, Ms. Tina Saraswat Pandey, for conducting the webinar so seamlessly. A big round of applause to Transition and our technical support teams whose behind-the-scenes efforts ensured the success of this event. Lastly, thank you to all the participants for your enthusiastic presence and dedication. Your involvement adds immense value to initiative like this. Together, as a part of IPNet, we continue to strengthen and grow the profession through knowledge sharing and collaboration. Thank you all once again. Thank you.
Thank you. Thank you so much.
Thank you so much. Thank you so much.
It was a pleasure to have all the members, including the former NCLT members. Thank you, sir. Thank you.
Thank you, sir.